On January 20, 2027, the European Machinery Framework changes. At the same time, ISO 12100 is being revised. These two developments are related to machinery safety, but they are not the same event. They do not have the same legal effect, and they must not be managed in the same way. Confusing them can lead a company to update the wrong documents, apply a draft as though it were binding, or assume that a familiar risk assessment method automatically settles every new regulatory requirement. In this episode, we will separate the legal change from the standards development process and translate both into practical actions for machinery manufacturers, system integrators, and technical compliance teams. Let us begin with the legal layer. Regulation European Union 2023/1230 on machinery entered into force in 2023, but most of its provisions apply from January 20, 2027. From that date, Directive 2006/42/EC is repealed and the regulation becomes the principal Union Act for machinery, related products, and partly completed machinery within its scope. This matters because a regulation is directly applicable in the member states. It does not require national transposition in the same way as a directive. However, that does not mean that every machine designed in 2026 automatically falls under the regulation, nor does it mean that all work performed under the directive becomes invalid on January 20, 2027. The decisive legal questions concern when a product is placed on the market or put into service, which product category it belongs to, which economic operator bears the relevant obligations, and which transitional provision applies. We will examine those questions in detail in another episode. For today, the important point is that January 20, 2027 is a legal application date. It changes the applicable Union framework and therefore affects conformity assessment, technical documentation, declarations, instructions, responsibilities, and the management of certain physical and digital risks. Now consider the standards layer. ISO 12100:2010 remains the published international standard that specifies basic terminology, principles, and a methodology for risk assessment and risk reduction in machinery design. It structures the process around the limits of machinery, hazard identification, risk estimation, risk evaluation, risk reduction, and documentation. In 2026, ISO is also developing a new edition under the designation ISO/DIS 12100.3. The letters DIS mean Draft International Standard. A draft is an important technical document because it shows the direction of development and allows national standards bodies and experts to comment and vote. But a draft is not the same as a published international standard. It must not be presented to a client, an auditor, or a market surveillance authority as though it had already replaced ISO 12100:2010. Until a new edition is formally published and its implementation status is established, the current published edition remains the applicable reference for work that cites ISO 12100. This distinction is not academic. A company may choose to monitor a draft, assess its possible impact, and prepare internal methods for future change. That is good standards management. But it should not silently rewrite formal procedures to state that the draft is already mandatory. Nor should it use draft clause numbers in a declaration or technical file without clearly identifying the document as a draft and explaining why it was consulted. There is another distinction that sophisticated organizations must understand. The validity of a technical standard and the legal effect of harmonization are separate questions. A standard may be technically current and widely recognized, yet presumption of conformity with specific essential health and safety requirements depends on the relevant standard reference being cited in the official journal of the European Union for the applicable Union Act and within the scope of that citation. The Annex ZA in the Polish and European edition of EN ISO 12100:2010 was prepared in relation to Directive 2006/42/EC. It should not be treated as automatic proof that the same edition, without any further legal step, provides presumption of conformity under Regulation European Union 2023/1230. The correct approach is to monitor the official list of harmonized standards and assess the exact relationship between the cited standard, its edition, the applicable legal act, and the essential health and safety requirements addressed. This is why a mature compliance system never stores only the text ISO 12100 applied. It records the full reference, edition, date, role in the project, and, where relevant, the legal basis for any claimed presumption of conformity. Let us now translate the two developments into a practical management model. The first workstream is regulatory readiness. The company should classify the products it places on the market or puts into service, identify the applicable economic operator role, review conformity assessment routes, revise templates for the EU Declaration of Conformity and the EU Declaration of Incorporation, check the requirements for digital instructions and digital declarations, and establish a process for substantial modifications, software changes, and protection against corruption or manipulation of safety-related control systems. The second workstream is standards readiness. The company should maintain a controlled register of standards, record the additions used in each project, identify standards that are being revised, assess whether a new addition affects existing design rules, and determine when internal procedures, checklists, and software templates need to change. The third workstream is engineering continuity. Even though the legal framework changes, the core discipline remains the same. Establish the limits of machinery, identify hazards and associated hazardous situations, estimate and evaluate risk, apply risk reduction in the prescribed order, verify the effectiveness of protective measures, and document the reasoning. A new regulation does not make poor engineering acceptable, and a new edition of a standard will not rescue a project whose decisions cannot be reconstructed. Imagine a manufacturer that hears two statements in a management meeting. The new machinery regulation applies in January, and ISO 12100 is being revised. The team responds by changing the title page of its risk assessment report, replacing the directive number with the regulation number, and adding the draft standard reference to a list of applied standards. Nothing else changes. The same spreadsheet is used, hazardous situations remain vague, evidence is stored in personal folders, software versions are not controlled, and no one has defined how to determine whether a machine was placed on the market before or after the transition date. This company has performed a cosmetic update, not a readiness program. A defensible program would ask much more precise questions. Which projects may cross the transition date? Which facts demonstrate placing on the market or putting into service? Which product categories fall within Annex 1? Which conformity assessment procedure is applicable? Which instructions may be digital and under what conditions? Which safety-related software is independently placed on the market? Which physical or digital changes could constitute a substantial modification? Which current standards are used and how will revisions be evaluated? Who owns each decision and where is the evidence retained? There is also a communication issue. Companies should avoid saying that Regulation 2023/1230 introduces risk assessment, as if risk assessment did not exist under the directive. They should also avoid saying that the new ISO 12100 becomes law. The regulation establishes legal obligations and essential health and safety requirements. Standards provide technical specifications and methods that can support compliance. The manufacturer remains responsible for determining and demonstrating conformity. A harmonized standard may provide presumption of conformity for the requirements it covers, but it does not transfer the manufacturer's responsibility to the standards organization, a consultant, or a software provider. That same principle applies to safety software. A digital system can help a team use one controlled methodology, record the current standard edition, connect hazardous situations to protective measures and evidence, generate reviewed documentation, and maintain an audit trail. It can also make gaps visible when a project crosses from one legal regime to another. But it does not itself decide which law applies to a disputed commercial transaction, and it does not turn a draft standard into a binding rule. The value of the system is that it helps the organization preserve the facts, assumptions, sources, approvals, and technical reasoning needed for a competent person to make and defend the decision. Before January 20th, 2027, every machinery business should therefore complete 4 checks. First, separate the legal transition plan from the standards revision plan. Second, confirm the status and edition of every document used in active projects. Third, identify projects that may be placed on the market or put into service around the transition date and retain objective evidence of the relevant facts. Fourth, test whether one completed risk assessment can be reconstructed from limits of machinery to residual risk, including who approved each protective measure and which evidence supports its effectiveness. If those 4 checks cannot be completed, the problem is not merely a missing declaration template, it is a process control problem. The final message is simple. On January 20, 2027, the applicable union machinery legislation changes. ISO 12100 is also under revision, but the draft development process has its own timeline and legal significance. Treat the regulation as a legal transition. Treat the ISO revision as a controlled standards transition. Connect both through disciplined engineering and traceable documentation. That is how a company moves from reacting to new numbers on a title page to making machinery safety decisions that can genuinely be defended. There is one further governance point that should be resolved before the transition. The company needs a hierarchy of controlled sources. The authentic legal act published in the official journal is the legal source. The current consolidated URLEX text is a highly useful documentation tool, but the company should understand that consolidated versions themselves state that they have no independent legal effect. Harmonized standard citations should be checked in the official journal. Standards should be obtained through authorized access and their edition status recorded. Internal procedures, training slides, and software templates should then be derived from those controlled sources. This prevents a common failure in which an old consultant presentation becomes the de facto law inside the business. A source control register should identify owner, last verification date, affected products, and required action after change. The same discipline should apply to translations. Machinery safety terminology is precise. The legal English term substantial modification should not be mixed with an internal expression such as major change without definition. ISO 12100 terms such as risk analysis, risk estimation, risk evaluation, hazardous situation, and hazardous event should retain their distinct meanings. When the company works in several languages, the source language and approved local term should be recorded. A poor translation can change responsibility or technical meaning even when the engineering is correct. Finally, plan competence. Legal transition training for sales and project management should differ from detailed technical training for designers and validators. Sales needs to understand product status and delivery assumptions. Project management needs transition gates. Designers need essential health and safety requirements and a risk reduction method. Compliance needs conformity routes and document control. A useful way to govern both changes is to create a 2-column impact register. In the legal column, record the affected product families, economic operator roles, transition assumptions, Annex 1 status, conformity assessment route, required declarations, instruction format, and release date. In the standards column, record each standard, its exact edition, citation status, functions or hazards addressed, projects using it, and the owner of the impact review. Do not merge these columns simply because the same engineer contributes to both. A legal amendment may change an obligation without changing the engineering method, while a new standard edition may change a design rule without immediately changing its harmonized status. The register should also distinguish 4 levels of maturity: awareness, impact analysis, controlled implementation, and verified use on a released project. Many organizations stop at awareness. They circulate a presentation and assume readiness. Verification requires selecting a real machine, following the new process from classification through release, and confirming that the evidence can be reconstructed independently. Senior management should receive a concise dashboard rather than a false percentage of compliance. Useful indicators include the number of projects crossing the application date, unresolved product classifications, open Annex 1 decisions, standards awaiting impact review, protective measures lacking verification evidence, and declaring generated from provisional data. The dashboard should identify the owner and decision date for every critical gap. This is also where external communication must remain disciplined. A company can credibly say that it has established a controlled readiness program, reviewed defined product families, and completed pilot projects. It should not make a blanket statement that every future product is automatically compliant. A precise scope statement is stronger than a broad slogan, because sophisticated customers understand that conformity is product-specific and configuration-specific. SafetySoftware can support the register by keeping the standard edition, project assumptions, risk scenarios, evidence and approvals in one traceable environment. The commercial value is not a badge. It is the reduction of uncertainty when a customer, auditor, or authority asks which rules were applied to a particular configuration and why. Software teams need version, intervention, and change requirements. Senior management needs evidence that the whole system is owned and resourced. Readiness is strongest when each role knows the decisions it must make and the evidence it must preserve.